Okay, welcome back, and thanks for your continued interest in this topic of the transfer of technology. My name is Anna Müller. I work for the WTO Secretariat in the Intellectual Property Division. Now I have to say that I'm specializing in my work on government procurement and competition policy. I'm also a trained IP lawyer, so it's not like I don't know anything about technology transfer. But I have to thank my colleague, Ms. Jashri Wattal, who's also working in my division, for basically giving me those slides and briefing me on the background of those. And I look forward to discussing the topic with you together. So the question that we're going to look at is how the TRIPS agreement, so the WTO agreement concerned with the protection of intellectual property rights relates to technology transfer and development of the business sector. In the second part of my presentation, I'm going to show you a few slides that basically show how Russia is doing right now on investment, on research and development, and how this can be relevant for the topic of technology transfer. Let's start with the question, what is technology transfer? We've already been talking about this topic all day, but I still think that we should go back and have a quick look. And you'll see that basically you can take a very large approach to what technology transfer actually is. It can be defined as any process by which the technical information of one party is acquired or learned by another and successfully incorporated into the latter's production structure. So it's about learning, and really what we don't look at is how this learning process is coming about and how this happens. It's just the fact that this learning process takes place and that the knowledge acquired is integrated into a production process. Now, this means that actually there's a number of ways in which technology transfer can happen. The information may, for example, be embodied in products, or it can be disembodied in blueprints, in more abstract information, in formulas, but also know-how. Or the technology transfer may simply involve purchasing an input or service and placing it into production without acquiring the know-how, really. So we see that technology transfer can be a more formal process or a very informal process, and this is gonna impact on how relevant IP and IP protection is actually for the technology transfer. Now, full technology transfer obviously requires knowing exactly how a process works, and as I said, this can be formal or informal. No formal transaction is needed in cases where technology can be easily imitated or copied. For example, software. There we have cases where reverse engineering, so-called reverse engineering, can already give you all the information you need to be able to copy the product. The same with some pharmaceuticals. As soon as you've the means to analyze the composition of that pharmaceutical, it's actually relatively easy to reproduce the compound and to produce the medicine. And here, obviously, IT is important for the owner of the technology, because IT is basically the main means of preventing the product from being copied by anybody who can acquire it. So here IT is important for technology transfer because IT is, on the one hand, the thing that makes you protect the knowledge that you have. It also makes you bring the product onto the market freely, because otherwise there may be a tendency to keep it a secret, actually. So very interesting here, what kind of role IP rights play when technology transfer can take place in this very informal way. And then here you only have an initial level of knowledge that's required, and the higher the initial level of knowledge, obviously, the quicker you can learn how to imitate or copy or reproduce the invention. And this will be relevant to the figures I'm going to show you later, because what you want to know is actually what's the level of initial knowledge that you can expect in Russia and what does this depend on. So how does technology flow across borders? Obviously, I'm from the World Trade Organization, so the first point we're going to put on these slides is trade in goods and services. He said technology transfer can actually happen very informally, so the mere fact of trading in goods and services can make your businesses know about a certain technology, the fact that it's available, and potentially even be able to copy that technology. You can have foreign direct investment, and this is something that relates back to a presentation we heard this morning about the oil rigs and the production processes related to energy here in Russia. And there the government had taken certain measures to actually encourage foreign investors to shift certain processes to Russia, but the presenter also said that this wasn't fully complete, that there were some things that these foreign direct investors didn't want to do in Russia, and this is why they brought in these ships with mobile platforms to actually perform certain other functions. Very interesting as well. So when you have foreign direct investment, obviously these companies are going to bring in certain knowledge, and if they employ people in the economy, then these people are likely to know about the processes, to learn, and that is one form of actually very positive technology transfer. Then the most formal way of transferring technology, and this was the subject of a presentation just before the break in one of the sessions here, was licensing. So here you have a well-established IP right, and the technology is then licensed out by actually providing a third party with the right to use the technology and to use the right, the property right, intellectual property right. Obviously, the most the most salient case here is licensing out of patents. But we also heard this morning that actually IP protection is very diverse. You can have trademarks, you can have industrial designs, and all of that is obviously part of the IP portfolio that can be subject to licensing, and that can be interesting in this regard. So licensing can take different forms. I don't want to go into too much detail here. Technology services are interesting. So there you have a service being provided. And what's interesting here is that the service can obviously be provided cross-border, so you can have personnel moving across borders. And there can be certain forms of technology transfer taking place like that. Then you have non-market channels, such as imitation, where the technology is in the public domain. And I already gave one example, so the technology can be in the public domain because you can just tell from the product itself, you can reverse engineer. Or it can obviously be in the public domain because an IP right exists. Don't forget that when you apply for a patent, when you register a patent, you actually have to disclose the invention. And this is the balancing factor in the IP system, is that you actually have to disclose the technical knowledge and the invention to the general public when you register the rights. So this is why society is actually willing to provide these private rights to the investor and to the owner of the technology. Now, why is the TRIPS agreement relevant to technology transfer? The TRIPS agreement is the agreement, the international agreement that actually sets minimum standards of protection for all different kinds of intellectual property. And as one of the pillars of the multilateral trading system, all WTO members are basically party to this agreement, subject to transitional periods and so on and so forth that are granted to developing countries, obviously. Now, what is the relationship between the TRIPS agreement and technology transfer? Basically, we have to first look at what effect these minimum standards of IP protection have on technology transfer. And the first thing we see is that if you strengthen IPRs, if you create intellectual property protection that wasn't there before, then you get more imports of IP-sensitive goods into your market. And we said that trade is one of the means to actually make technology transfer happening. We also see that this is more efficient, this effect comes out more in countries with effective imitation threats. Why is that? Because obviously, if a company fears that the product is going to be imitated in a market, then it's going to prevent the product from actually being exported to that market unless there's effective IP protection. So IP protection and a basic level of IP protection here becomes, so to say, a condition that you need to fulfill in order for the holder of the technology even to be willing to export the product into your market. So we see that actually high-tech exports happen to reforming countries, and they are actually higher than low-tech exports in the time after the TRIPS agreement was adopted. And we see that this is significant in OECD countries, and some also developing countries have been benefiting from this effect. Then some researchers have found that patent reform has significant impact on export in both developed and developing countries and in high-tech areas. So again, we see this relationship between trade and IP protection in intensive products. We also see some impact on the inventive activity. And we see that the inventive activity goes up in countries that have inventive potential, that didn't have IP protection before. If you then introduce IP protection, then your inventive activity actually has a significant increase. But obviously, this is somewhat different in countries where you already had IP protection before, and it obviously depends on the inventive potential. Now, in the interest of time, I'm gonna basically go directly to TRIPS and inventive activity. We see that, for example, in India, Indian pharmaceutical firms increased the R&D to sales ratio a lot after intellectual property protection kicked in due to the TRIPS agreement. And this is also true in the US, in China. But, for example, some other studies showed that this was the case for Japan, but not for Korea. So we don't have a very, very direct relation here. And the evidence that we see is more anecdotal than really 100% foolproof for all situations. Now, the question that we really want to ask, obviously, today is what can be done to increase technology transfer? And let's discuss some solutions. Now, you can take a legal view basically a country can legislate to access patented technology. You can, for example, impose technology transfer on foreign direct investors. You can have patent exclusions for certain technologies, so then you free ride on the information that's out there in other countries, and you basically don't grant protection for these patents in your economy. You can revoke patents, you can issue compulsory licenses, or government use orders. So this is one means of state intervention to actually access technology. You can also take an administrative view. So you can construct mechanisms to facilitate technology pooling or placing it in the public domain. You can create centers where knowledge exchange can take place, and you can thereby just create the means of facilitating technology transfer. And here you have, again, different options to make this voluntary or compulsory. How am I doing for time? Still have a few minutes, I hope. Okay, good. Yeah, the aim always is to facilitate patenting and licensing. Or can be. There's fast-track options for certain patents and licenses. You can also just provide the better flow of information. So you can basically create databases in order to increase the information that's in the public domain for patented technologies or other technologies that are actually available, and to encourage their use. And you can basically create economic incentives to incentivize technology transfer and innovation. And one of the measures here that you can obviously take, again, let's go back to the idea that technology transfer can take place through trade, is to remove barriers to trade, obviously. But it's also about removing about creating adequate infrastructure and to increase the skill levels. And yeah, this is really linking back to the figures I'm going to show in a minute about the situation in Russia. I would suggest that probably it does make sense to think about, first and foremost, of this economic view, to see what can be done to actually create good conditions for technology transfer to happen. Now, you're going to ask me how much technology transfer is actually taking place since the CHIPS agreement was adopted. And the first problem we have here, obviously, is how to measure technology transfer. There's two ways currently to do this. Some people look at patent counts. How many patents are registered in a country by foreign firms? But obviously, this patent count will only show the patents registered. And we said before that actually there's also informal technologies. There may be technologies around that are not patented. And also, we said that technology transfer supposes that there's some kind of absorption of the knowledge and integration into a production process. And this is also not measured by mere counting of patents registered, obviously. So that's one way of looking at it, one potential indicator, but obviously not a very precise or clear indicator. And then the second indicator that other people look at are royalty and licensing fees and the flow of these fees across borders. So that's a second one. Again, there you have royalty fees. That's again relating to only one form of technology transfer, obviously, the licensing out through formal licensing agreements. And we said before that technology transfer is actually a term that can cover wider means of transferring technology than just licensing out. But obviously this is the most evident one. But all these proxies are obviously problematic. And what we see is that technology and technology transfer is obviously very different from other commodities, and this is why it's so difficult to measure. Now, what we see is that if we look at these royalty and licensing fees, they increased a lot over the last 20 years. It's really impressive how the adoption of intellectual property laws across the world actually led to this increased trade in IP, so to say. Because what you really look at here is not trade in goods or trade in services, but trade in IP, or IP as a service in a way. And what we see is that this trade in IP as a commodity is taking place a lot between countries that are very advanced already. So the thing that I said, one has to create the conditions, and one wants to create an economy where the uptake of technology is actually very easy in order to increase this technology transfer, is confirmed in these figures. If you have a situation in the country where companies are already relatively sophisticated, they're more likely to trade an IP across borders. But we see that actually the picture is changing, and middle-income countries are catching up slowly. So there we see that countries are actually developing, they're getting more sophisticated in the technologies that they can use, and this is reflected in increased technology transfer that is taking place. And this trend also goes very well with the general trends that we see, just to clear the globalized world, the globalized trading system, and global value chains. Obviously, IP is always something that is supposed to lead to a product. So if you produce internationally, you will have some of that technology transfer taking place. And it's all about moving up to in the global value chain to the more technology-intensive production steps. IPRs obviously can hinder. Well, the question is, do IPRs only help, or can they also hinder transfer of technology? We said, in the event that the information is out there in the public domain and you can just copy, you could at first think, oh, the IPR is the one thing that actually prevents me from using that technology. So it could be seen as a hindrance. But then again, if you think of it, you reduce the incentives to keep technology secret, to prevent a product from moving across borders. So in that sense, IP obviously helps. And what we see, that stronger IPRs lead to more trade, more FTI, and through this to more technology transfer, because you reduce these barriers that may prevent firms from actually bringing high technology products into your country. Yes, skip over that. Yeah, some, as I said, say that stronger IPRs block learning by imitation, and there's some anecdotal evidence for that. But the general idea is that IPRs are actually the one means that you need in order for a licensing agreement, for example, to happen. The TRIPS agreement has one single article that actually addresses technology transfer directly. And this is Article 66.2. It doesn't concern Russia directly, because this is an article that actually deals with an obligation by developed country WTO members to provide incentive to enterprises and institutions in their territories to promote and encourage technology transfer to least developed country members. Russia would obviously not count as a least developed country, but we see that this article can still be useful to Russia, because basically on the basis of this article, the WTO members took a decision in 2003 that obliges developed country members to submit annual reports on actions taken or planned in regard to this obligation. And they do submit these detailed reports, and they're discussed in the TRIPS Council. They have to update them. And here I give an overview of the information that needs to be provided. The one thing that I want you to take away from this article is that here you have a resource, a wealth of knowledge that's actually available of what can be done to favor technology transfer. Because you there have a very good overview of what developed country members think is helpful in promoting technology transfer. So this can be used as a source of information and inspiration for the government in order to see what it can do itself to actually promote transfer and technology. Yeah, so there's a bit of a debate regarding these reports, what they should actually contain, what the structure should be, and one of the issues is, and this was the start of my presentation, the definition of technology transfer, because obviously one can disagree on this point already. But really, for Russia, I think, for the Russian Federation, the most important thing to take away is there are these reports. They're publicly available on the WTO website, and obviously also to Russia as a WTO member, to the delegation. And this can be taken as one source of information on what to do in order to support technology transfer. And now, if I have still 2-3 minutes, yeah? We can quickly look at some data that we found on how much different countries, different regions actually invest in research and development and what the output is here. And again, these data that I'm going to show you are not WTO data. They're not based on WTO statistics. They don't reflect an official WTO view or assessment, obviously. It's just something that I would like to show you. These are publicly available on the internet from certain research institutes, and just as a basis for discussion. And I would like to go through these with you. Here you have a slide that shows the relative amount of annual research and development spending by the indicated country. So you have the number of scientists and engineers per million people in the country here, and research and development as a percentage of gross domestic product, of GDP here. And the size of the circles show the absolute amounts of spending. What you see here is that the United States really is up here, big spender on R&D, relatively high in the number of researchers, so it's up here, and also spending a lot as a percentage of GDP on research and development. You see that South Korea and Japan and Sweden and Finland, for example, are still spending more, and Israel is here. In absolute terms, it doesn't spend that much, but in terms of R&D as percentage of gross domestic product, it's really here the outlier that spends a big percentage of its GDP on research and development. And this is very interesting factor. You see, if we now look at the BRIC countries, China is spending a lot in absolute terms. It's a big circle here. Relatively low number of scientists and engineers. It's down here. And Russia is doing better in terms of scientists and engineers per million people, but in absolute terms is spending much less than China. Much smaller circle, and also less in terms of percentage of GDP. Just to show you, Brazil is here, and who finds India? Where's India? I don't see India. But left to China, Iran, India. Yeah, here, exactly. So spending about the same amount as Russia, but Russia is doing much better in terms of GDP, as R&D as a percentage of GDP, and also in terms of the number of scientists. And this is basically showing with the trends over the years. What you see is China and Russia are both going up, but still not reaching the levels of South Korea and the United States, for example. You see, if you look at it as a region, Europe is spending 24% of what? I don't know, 345 billion of US dollars. America is slightly higher. In Central Asia, yeah, of the total spending of the country, probably, I don't know, of the region. But anyway, Central Asia, 2.5% only, and about 1/10 of what Europe spends. So that's significant here, the discrepancies. Here we see the estimated number of researchers, and very interesting, China is going up like a rocket here. Then going down again. Russia is slightly on the decline here, but more or less stable. Again, interesting, whereas the EU is getting more and more researchers. And here we have global exports of royalty and fees by region. Unfortunately, Russia is not really spelled out here. We see that overall in the world, royalties and fees are going up. United States going up slowly, EU going up slowly, Japan, and other developed also going up slowly. So there's a trend for R&D to go up. Unfortunately, we don't have specific figures for Russia. Here we see the output of high technology manufacturing industries for regions. Again, we don't have specific figures for Russia, unfortunately. We see again that here we have a big increase. So developing countries are really on the rise in terms of high technology manufacturing, which is good news for development. Here we have specific figures for Russia. And this is the output of knowledge and technology intensive industries as share of GDP. And we see that if we compare the figures from 1995 to 2010, unfortunately I don't have the 2015 figures yet, you see that there's a big an increase in commercial knowledge intensive services in Russia, but a decrease in high technology manufacturing. Interesting. And public knowledge intensive services are staying about the same in Russia. Now, that was basically my presentation, and I thought these figures were particularly interesting to me. This was something that I researched particularly for this presentation, and that was new to me, so I learned a lot. And thanks for inviting me to give this presentation. That was very useful to me. What we see is that IP and technology transfer is linked. IP protection and trade is linked, and trade is one of the factors impacting on technology transfer. Really, what is the question that we all need to ask is what measures are needed to increase transfer of technology, and all these figures on spending on R&D and creating the environment for technology advancement are really very interesting in that regard. That's my personal belief. And I think the importance of investment in R&D shows, if you compare these figures, we said the US is the one that is earning the most in terms of royalty payments, right? We also see that the US is investing a lot. So you see here that there's a direct link between the level of IP protection you provide, the level of research and development spending, and how much you are an exporter of technology. At the same time, if you want to basically receive technology as an inbound transfer, you still have to do the spending on research and development. You still have to have the scientists in your country in order to increase the uptake of the technology and to reduce the time that your companies need to actually produce using that technology. So the importance of investment in R&D and in intellectual property is really great here. And then hopefully a country can go from a net importer of technology that is receiving technology transfer to an exporter of technology-intensive goods and services. Thank you.
Соглашение ТРИПС, его значение заключается в том, что предоставляет национальный режим для иностранцев. Но главная проблема международного правового регулирования патентных отношений заключается в том, что, к сожалению, пока отсутствуют международные патенты. Все патенты на полезные модели, изобретения и другие объекты промышленной собственности подлежат регистрации в соответствующих национальных патентных службах. В этой связи вопрос. А планируется и вообще обсуждается ли вопрос в рамках ВТО, вопрос о создании, может, какой-то международной патентной системы, где бы существовали патенты, которые будут применяться одновременно на территории нескольких государств? Это вопросы конвенции, которые упрощают подачу заявки, но не более того. Но патент носит национальный правовой характер.
Thank you very much for that question. It's a very good question, because if you look at international trade and IP, obviously the easiest solution would be for a company, and from the private sector standpoint, to register one invention in one office and have worldwide protection. Now, this is not the case. This is why, actually, the reason why the TRIPS agreement exists, because there is not one global patent. And in the WTO, there's currently no discussion on creating a global patent. What exists is the Patent Cooperation Treaty. This is administered by the World Intellectual Property Organization, not by the WTO. And it facilitates the registration of patents in several jurisdictions at the same time, so that the administrative burden of filing for patent protection gets reduced. And this is something that has been done. This still doesn't mean that it's a global patent. And I can tell you that from a European Union perspective, the European Union managed quite quickly to have what we call the European trademark. So there's the possibility of getting a trademark that is valid in all European Union member countries. But for patents, that was much more difficult. So there is a European Patent Office, but the European Patent Office was very similar to this process that we have in WIPO. It facilitates the filing of the patent, but then you would get several patents for all the different countries. So the law in terms of intellectual property still remains essentially national, and the role of the TRIPS agreement is to provide a minimum overall standard for IP protection across different countries. So this is the purpose of the TRIPS agreement, is to respect the national sovereignty in providing patents, and to create a minimum standard of protection across countries, but it doesn't take away the sovereign power of individual states to decide on whether a patent should be granted or not.
Thank you very much for the presentation, and now we have to continue with the other presentations. If we have any questions to the speakers, we can also ask them at the end of the second day.
Thank you for this opportunity to talk to you about WTO issues, which you already addressed quite in some detail this morning. I'm a German-educated lawyer working in Brussels for the last 25 years on competition issues, state and traditional trade matters, in particular WTO, dumping and subsidies. Now what we have today are issues which you discussed earlier this morning, and where we have quite a number of disputes between the European Union and Russia. It is quite normal that you talk about issues and disputes in the WTO, and with the changes in 1994, when the WTO was created, we got first of all a functioning dispute settlement system which works very well. Now, let me briefly talk about the 6 dispute settlement proceedings and then see what we can retain from these. Now, the first one is a recycling fee on motor vehicles which was brought by the EU. The second one is a case which was brought by the Russian Federation. It concerns the calculation of certain costs in anti-dumping measures, and it may be that my learned brother Nikolai Mitsulin talked about that this morning. The third one concerns measures on importation of live pigs and other live animals brought by the EU. Then we have a case which refers to measures taken by the EU. These are measures in the energy sector. In particular, it concerns the so-called third energy package of the European Union. I will come back to that later, but in brief, the third energy package requires energy utilities to behave without discriminating against each other. It ends the previous territorial protection which they had, and it liberalizes the energy market. This is of particular interest in relationship with Russia, because there we have a number of monopolies and we have a number of long-term agreements which have the effect of, or can have the effect of foreclosing markets and of stifling competition. Next one concerns anti-dumping measures on light commercial vehicles. That is something which was also touched upon earlier today. It is a measure taken by the Russian Federation against vehicles from Italy and Germany. And the final one concerns the tariff treatment of a number of agricultural products are challenged by the European Union. You will all receive the presentation, so I do not want to go into details of each and every case, because that would take us much further. I would rather want to put some basic issues to you and to discuss with you some principal questions, so that we have an exchange of opinion rather than a lecture in the traditional format. Now, the principal questions which I want to put to you, and these are the questions which concerns all these cases, are the cases: what do you want to achieve, and which options are available? This is where lawyers come into place, because we are outside from a government, from an association. We have special knowledge, and we can help you to look into the options which are available to you. And with that, let me jump to one of the first cases. First and the last case. The first is the recycling fee on motor vehicles. Last and the last concerns the tariff treatment of agricultural products. Now, if we look at the first case which was brought by the EU, it concerns a recycling fee on motor vehicles. And there you see the measure which is taken exempts domestic vehicles. Exempts vehicles from Belarus and Kazakhstan, and it differentiates between new and older cars. Now let us go back to basic question, what do you want to achieve? And if you allow me to quickly go to WTO or GATT obligations, which the Russian Federation subscribed to when joining the WTO, it is quite obvious that these measures are contravening GATT obligations. Let me go to, for instance, Article 1.1. Read the underlined text. With respect to charges of any kind imposed on or in connection with importation, any advantage, favor, privilege, or immunity granted to any product originating in that shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other contracting parties. When we go back to the facts, if you distinguish between vehicles which come from the EU and vehicles which come from Belarus and Kazakhstan, you see already run foul of this article. And we can go on with that. I think just to recapitulate two basic principles. The first basic principle is that if you give any advantage to one country, you have to give that advantage to all other countries. One basic rule. Otherwise, it does not make sense to bind a tariff on a certain product. Second basic rule, and this you have here, Article 3, national treatment, means that you cannot discriminate between national products and products which you are importing. So these are very basic rules, and I think if you look at the facts, and you will have the presentation later on, if you look at the facts of the cases, you will already see for yourself that Russia cannot win a certain number of cases. And that brings me back to the questions, what do you want to achieve? Now when I talk about Russia, it is because we have these cases. It is not just to single out Russia, you have the same type of disputes with everybody, with any new country joining the WTO, or do that for particular political reasons. And with that, let me then, rather than go through all these cases, because we are already coming close to the 10th minute, and I understand that your attention span will then significantly diminish, come back to the basic questions. What do you want to achieve? And this is then a question which you, as industry representatives, as government representatives, have to discuss with consultants and with lawyers who have specialized expertise. I think if we look at the cases, some of them are more factual based, then you will see in discussing this that you can have, or devise certain solutions where you can carve out an advantage for domestic industry or for somebody importing without running foul of all these rules. I remember 1 year ago we were asked to help a car company when the advantages granted under the trim agreements and the temporary rules in the accession agreement between Russia and the WTO ran out, how to find a way to safeguard certain advantages. And these questions are very facts-based. Look at law. The law in many cases is quite clear. Like the questions which we have here, you cannot discriminate between imported products and between national products. Must accord the same advantage to a product coming from a third country to any other third country. Then again, you can come up with a solution where the facts of this product coming from a third country are simply slightly different from the facts for another third country, and then you can come up with a rule which helps more one company than another one. We have, to jump to something else, we have in the EU similar situations where EU rules can sometimes be better for the industry in one country than for the industry in another country. Think of the emission rules for cars. They can be devised in a way that helps one country or the industry in one country rather than the other country. That I would like to close and forward to your questions.
Спасибо за доклад. Какие вопросы к спикеру? Нет вопросов, да?
Good afternoon, ladies and gentlemen. Well, first of all, thank you very much to the organizers of this WTO forum for inviting me. It has been a pleasure. And well, unfortunately, I'm afraid to tell you that those who have attended to the session regarding the transportation in Kaliningrad, this presentation could be redundant. Okay, so thank you. Well, this talk deals with Article 5 of the GATT, which is the freedom of transit, and its implementation in Russia and Kaliningrad as a special economic zone, before and after the Russia's accession to the WTO on the 22nd of August of 2012. As you can see on the program of the WTO Forum, the title of this presentation initially was only related to the freedom of transit, Article 5 of the GATT. So, but due to the fact that there are some particular problems, especially with Lithuania here in Kaliningrad, I just added a small summary of this problem with my view about that. Well, this first part of the presentation explains the notion of the freedom of transit pursuant to Article 5 of the GATT 1994, and also according to the panel's interpretation in the Colombia Ports of Entry case, which is the only one WTO case that we have regarding the freedom of transit so far. Nevertheless, to understand Article 5 of the GATT, it is important to note that customs transit is a suspensive regime that can be defined as follows. Customs transit allows for the temporary suspension of duties, taxes, and commercial policy measures that are applicable at import, thereby allowing customs clearance formalities to take place at the destination rather than at the point of entry into the customs territory, which could be, of course, should be in that case, an importation and not transit. Well, Article 5 of the GATT is divided into 7 paragraphs. Paragraph 1, as you can see here, defines the concept of traffic in transit as goods and means of transport that are in transit when the passage is the only portion of a complete journey beginning and terminating beyond the frontier of a contracting party. In other words, goods in transit are not intended to be introduced onto the domestic market of the transit state. Goods, as I said before, would be just an importation. On the contrary, they are intended to be in a suspensive customs regime until they reach their state of destination. Paragraph 2 is divided into two parts. The first sentence describes that the freedom of transit shall be performed via the routes most convenient for international transit. Even though in the Colombian ports of entry case, the panel did not define the meaning of the routes most convenient for international transit, it pointed out that goods in international transit from any member must be allowed entry when destined for the territory of a third country. Reasonable in the panel's view, a member is not required to guarantee transport on necessarily any or all routes in its territory, but only on the ones most convenient for transport through this territory. Of course, this clarification respects the principle of sovereignty of the transit states and makes it also compatible with the interests of international transit. The second sentence relates to the principle of non-discrimination. Accordingly, in the panel's view, the second sentence complements and expands upon the obligation to extend the freedom of transit based on the principle of non-discrimination. Therefore, the second sentence requires that goods from all members must be ensured an identical level of access and equal conditions when proceeding in international transit. Paragraph 3 establishes that traffic in transit on the basis of the freedom of transit shall not be subject to unnecessary delays or restrictions and shall be exempt from any customs and transit duties. This idea strengthens the concept of transit as a suspensive customs regime that shall be performed in a free way, that's it, respecting the freedom of transit. In line with paragraph 3 of this article, paragraph 4 also strengthens the concept of transit as a suspensive regime based on the idea of free transit, setting up that those checks and regulations imposed on traffic in transit, entailed by transit, or with the cost of services rendered, shall be reasonable. Paragraph 5 establishes the most national favorite treatment concerning all checks, regulations, and formalities in connection with transit, specifying that the MFN protection extends to like products being transported on the same route under like conditions in relation to transportation charges. According to the panel, the protection under paragraph 5 broadly extends to all regulations and formalities for all traffic in transit. According to the panel in the Colombia's ports of entry case, while Article 5, Paragraph 2 of the GATT extends the MFN protection to goods in transit through member countries, Paragraph 6 extends MFN protection from discrimination based on the geographic course of goods in transit upon reaching their final destination. In view of that, the panel stated that Paragraph 6, first sentence, requires members to extend the MFN treatment to all goods that have been in international transit, except with respect to specific pre-existing direct consignment commitments. As you can see here, also in the second sentence, in relation to the date of this agreement, which is there, is underlined, for all accessions to the GATT of 1947 thereafter, the accession protocol provided that the date of this agreement, for the purpose of Article 5, Paragraph 6 of the GATT, was the date of the protocol of accession or of provisional accession. These accession protocol provisions are incorporated into, by virtue of 1B2 of the GATT, to the GATT incorporation text. Paragraph 7 clarifies that the freedom of transit in WTO does not apply to traffic to aircraft in transit. This is an exception to paragraph 1, which includes means of transport within the concept of traffic in transit. And of course, it could be also thought that maybe aircraft is also included, but not. The reason for these paragraphs is that the freedom of the air are regulated by the Chicago Convention on 1944, which is the Convention on International Civil Aviation. Well, after clarifying the WTO freedom of transit provision, it is interesting to analyze the relationship of this provision with other legal provisions. Concerning the MFN treatment, the panel in the Colombia ports of entry case pointed out that while Article 1, Paragraph 1 of the GATT ensures MFN treatment to like products of all origins, Article 5, Paragraph 6 of the GATT ensures MFN treatment, as I said before, based on its transit trajectory, regardless of the existence of a like product of a different origin. Therefore, even though both legal provisions deal with the MFN treatment, the obligations in these two provisions are not the same, and accordingly, they should not be considered as redundant. In relation to energy transit, the relationship between the Energy Charter Treaty and the GATT is established by Article 4 of the Energy Charter Treaty, which establishes the non-derogation of the GATT provisions. Accordingly, the energy transit of the ECT, which is the Article 7, must not derogate from Article 5 of the GATT, which is the freedom of transit. Russia signed the Energy Charter Treaty in 1994 and accepted provisional application of the treaty pending ratification. However, it withdrew from the Energy Charter Treaty so that the last day of Russia's provisional application was on the 18th of October 2009. Consequently, Article 7 of the Energy Charter Treaty is not applicable to the Russian Federation anymore. Regarding to intellectual property rights, Article 51 of the TRIPS Agreement establishes in its footnote 13 that there is no obligation to apply such procedures of Article 51 of the TRIPS to goods in transit, which does not mean that it may not be applied. Since, according to the general rules interpretation of the treaties, Article 51 of the TRIPS must be interpreted taking into account Article 5 of the GATT 1994 in this particular case. Article 51 of the TRIPS could be interpreted as a lex specialis to the freedom of transit due to its more specific provisions concerning IP rights, and because all GATT signatories are also TRIPS signatories as WTO members. On the subject of trade facilitation, the last version of the WTO Trade Facilitation Agreement was agreed on the 7th of December 2013 at the Bali Ministerial Conference as the part of the Bali package. WTO members adopted on the 27th of November of 2014 a protocol of amendment to insert the new agreement into Annex 1A of the WTO agreement. Hence, the Trade Facilitation Agreement will enter into force once 2/3 of the WTO members have completed their domestic ratifications process. And by the way, I just read yesterday that the WTO expects that by December of 2015, so this year, in the Nairobi conference, all the WTO members, they will ratify this Trade Facilitation Agreement, but we'll see. Based on Article 5 of the GATT 1994, Article 11 of the Trade Facilitation Agreement regulates the freedom of transit in a deeper way, complementing Article 5 of the GATT 1994. Thus, it regulates issues like the imposition and characteristics of charge, regulations or formalities, the exemption of traffic in transit from customs duties, the management of a possible warranty for goods in transit, and even the creation of a national transit coordinator for the appropriate implementation of the freedom of transit. Accordingly, Article 11 of the Trade Facilitation Agreement could be interpreted as a GATT plus legal provision that will improve the protection of the freedom of transit established by Article 5 of the GATT. Well, as I told you, till here should be my presentation based on Article 5, but I think it's interesting also to see a bit what's going on here in Kaliningrad. So, I'm regarding, as you can see here, to the particular case of Lithuania with Kaliningrad, and also we will see how the freedom of transit between Kaliningrad, let's say Russia, and the European Union is regulated. Well, as it can be observed in this map, Kaliningrad is a Russian exclave with access to the Baltic Sea, located between Poland and Lithuania. It has a special economic zone status until the 1st of April 2016, if it is not renovated, which entails favorable rules for payment of customs duties and incentive for large investments. However, although Kaliningrad belongs to a special economic zone, the advantages offered to the enterprises cannot overcome the cost of transit in terms of energy, time, transport, storage, etc., through the neighboring countries of the European Union. Thus, to the particular geographical situation or condition, transit of goods between Kaliningrad and the rest of the Russian Federation plays an important role in the Kaliningrad economy. In this sense, it is noteworthy, this case that I mentioned before, between Lithuania and Kaliningrad. And it was, by the way, very well analyzed indeed in this session of this transportation in Kaliningrad. Well, to understand this mentioned issue, first of all, it is important to set forth how transit of goods between Kaliningrad and the rest of the Russian Federation throughout the European Union territory is regulated. Firstly, there is the Partnership and Cooperation Agreement, which sets the framework for bilateral cooperation and determines the conditions for trade between the European Union and Russia. Title 3 thereof regulates trade in goods and incorporates by reference the MFN treatment, the national treatment, and the freedom of transit of the WTO. In fact, one of the objectives established in Article 1 of the PCA is to create the necessary conditions for the future establishment of a free trade area between the community and Russia, covering substantially all trade in goods between them. Therefore, the PCA regulates transit of goods respecting the principle of non-discrimination and on the basis of the WTO freedom of transit. Secondly, on the 27th of April 2004, a joint statement on the European Union enlargement and the European Union-Russian relations was adopted. It acknowledged the opportunities between the European Union and Russia for increased and intensified cooperation offered by the European Union enlargement of 2004 and confirms the way that enlargement-related issues have been and will be addressed. As it can be observed in this slide, it also emphasized the relevance of the freedom of transit of goods, including energy, for the Kaliningrad and the Russian economy, containing provisions that ensure its efficiency. Regarding the European cooperation with Kaliningrad on transit of goods, the European External Action Service gives the following practical examples. They are based, by the way, on the PCA. There has been some emphasis on improving the infrastructure and functioning of Kaliningrad border crossings to help solve the frequent problem of long queues of lorries waiting to cross the border into Kaliningrad. The Russian and Lithuanian customs authorities have been working with the Commission to help making transit arrangement functionally smoothly. And I have to read that because I don't, it's Chernyshevskoye or something like that, I'm sorry for the pronunciation. Well, this border crossing point on the Lithuanian border was opened in 2009 with the help of 8 million euros investment. The new crossing point has the capacity to handle the high volume of traffic on this important trade route. Heavy road traffic started to cross the border at Mamunowo on the Polish border in 2007. And with the help of 13 million euros investment, this crossing point was completed in 2009. Thirdly, with Russia's accession to the WTO on the 22nd of August 2012, the freedom of transit of goods between Kaliningrad the rest of the Russian Federation and the European Union is clearly reinforced. Accordingly, the WTO accession improves the competitiveness of the Russian economic and integrates it into the global marketplace, offering an appropriate dispute settlement for trade disputes, also concerning, by the way, the freedom of transit. In this sense, the WTO has become the most effective system of dispute resolution in international law. The WTO system, the dispute system mechanism, approaches this dispute through consultation or litigation process, which is rule-based, predictable, and respected. As mentioned before, there is a transit conflict between Lithuania and Kaliningrad that damaged Kaliningrad economy. This issue can be better resolved after the Russia's accession to the WTO due to the city WTO dispute settlement mechanism. As it was already explained before in the other session, the state-owned company Lithuanian Railroads establishes every year a base fare for railroad transit and a set of coefficients. However, Lithuania applies different coefficients depending on the origin and destination of the goods in transit. In other words, Lithuania establishes an exception of this good transported from and to the Kaliningrad region, which have higher values. On the contrary, the coefficients applied to and from the Klaipėda port, which is situated in Lithuania, into other countries also, are significantly lower, which clearly encourage the transit flow to the Klaipėda port, in this case of Lithuania, in detriment to Kaliningrad. This situation creates a different level of access and differential conditions for transit of goods, which implies discrimination. Accordingly, it could be interpreted only this transit of goods, as a breach of the MFN principle by Lithuania, as has been explained in the first part of this presentation. While Article 5, Paragraph 2 of the GATT 1994 extends MFN protection to goods in transit through member countries, Article 5, Paragraph 6 of the GATT ensures MFN treatment based on this transit trajectory, regardless of the existence of a like product of a different origin. Furthermore, Article 5, Paragraph 5 of the GATT establishes this MFN treatment concerning all checks, regulations, and formality in connection with transit. So, in relation to the case that concerns us, it can be understood that Lithuania violates Article 5, Paragraph 2, second sentence of the GATT, also Article 5, Paragraph 5 of the GATT, Article 5, Paragraph 6 of the GATT first sentence, this is concerning to the MFN treatment, because the different treatment of the goods in transit regarding church regulations and formalities, that's it. The application of different coefficients that creates a discrimination in the traffic in transit of both states is based on the origin, destination, and trajectory of the goods. Also, you can see here, concerning the cost and church, Lithuania also violates Article 5, Paragraph 3 of the GATT because the costs are excessive due to the high tariff applied to Kaliningrad. Likewise, there is a violation of Article 5, Paragraph 4 of the GATT because charges applied to Kaliningrad are clearly not reasonable. So, just to conclude, well, the status of Kaliningrad as a special economic zone has benefited the Kaliningrad economy. However, it does not regulate the issue of transit of goods. The freedom of transit of goods, as I said, is regulated by the Partnership and Cooperation Agreement. Also, we can take a look at this joint statement, but it's also regulated by WTO law, which is very important. Thus, transit of goods between Kaliningrad and the rest of the Russian Federation through the European Union territory is legally well guaranteed by means of the PCA, which has been reinforced, as I said, after this Russian accession to the WTO. Accordingly, the transit issue with Lithuania can be better resolved now that Russia is also a WTO member due to the WTO dispute settlement mechanism. So, as it was already explained before, I mean, it is up to you, up to the Russian government to decide actually what's the purpose of this. So they can go or they cannot go to the WTO to resolve this dispute. But it's likely, other experts says, and I also think like that because actually we reached the same conclusion of violating of Article 5 of the GATT completely, is that probably, I mean, Russia, I think, has possibilities to win the case in the WTO. By the way, something that I said also in the other presentation is that I didn't add here Article 1, Paragraph 1 of the GATT, which is the most favored nation treatment in general terms, and the Article 3 of the GATT, which is the national treatment, because they are related to imports. And I am just explaining transit, okay? So transit of goods. That's why, according to transit of goods, in my view, there is only a violation of Article 5, but it's a complete violation of that. Well, thank you very much for your attention.
Thank you for the very interesting presentation and enlightening it, even though some of the issues were already covered during the previous one. We, Russia, we have a fundamental disagreement with the European Union on the coverage of second sentence of the second part of Article 5. We believe that it does not contain a national treatment obligation. Europe strongly believes that it contains a national treatment obligation. That's why Europe put an amendment in the context of the trade facilitation agreement to clearly spell out that the no distinction shall be made language also entails a national treatment obligation. I mean, for us, the issue is of significant relevance in the context of the energy transit. It might be of importance also for the issue of Kaliningrad, even though for Russia to rely on this issue in the context of a challenge would mean revising its principled position on the second sentence. But the question is, in your opinion, under the second sentence of the second paragraph of Article 5, is there a national treatment obligation that will require to treat goods in transit in the same way as the goods originating or destined for the country of transit?
So you mean the second sentence, right? Yeah. So no distinction shall be made, which is based on blah, 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 and then the place of origin, departure, entry, exit, or destination. On any of the circumstances or the. I mean, I do think really that this is an MFN treatment. I mean, I disagree with that view of Russia because we have.
No, we say it's MFN. Europe says it's national treatment.
Oh, in my view, it's MFN. And are you sure about that? Because the panel in the ports of entry case said that it's MFN treatment too. The panel. And it's the only one WTO case that we have resolved till now so far. So, and I agree with the panel because we have to read Article 5, Paragraph 2 of the GATT in line with the rest of the article. So, first of all, in Article 5, Paragraph 1, we have this definition of the traffic in transit in general. And then we go to Paragraph 2, and there's establish the obligation to have this freedom of transit through these routes most convenient for international transit. And then this no distinction shall be made, which is based on the flag, blah, 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 origin or destination of the goods. In my view, we have to read this in relation to sentence 1 of the same paragraph, which is also related to the previous paragraph, which is traffic in transit. So I totally agree with the panel in that case, and I would say that this is MFN treatment. In that case, oh sorry, because about transit. But why is also MFN treatment? Excuse me. Well, because if you have here, you know, this distinction between entry, vessels, place of origin, etc. I mean, in the MFN treatment, you cannot have, a distinction between a country. You have to have, you need to have the same benefits or preferences to every single country that you have to the most favored nation treatment, so the most favored nation country. So you have to apply the same. And if you apply different things because of this relation of words here, then of course you are violating the MFN treatment, which is regulated in Article 1, Paragraph 1 of the GATT for imports, in my view. Oh, and sorry, and by the way, the MFN treatment, like the national treatment, is anyway a part of the discrimination principle.
Well,
I do think so.
no, but you under the 5.2, to the extent that the second sentence only covers MFN, you're certainly entitled to charge the transit one fee, to charge purely domestic transport a different fee. That's what we in Russia say. Europe says no. To our transit, apply what you apply for the domestic transportation. And we have been debating it now at length, and the European Union's position remains, yes, we offered an amendment in the trade facilitation, doesn't mean that we do not believe that national treatment is not in this sentence.
So you mean that would be national treatment and no most favored nation treatment?
Yeah, Europe believes that MFN and national treatment are covered by the second sentence.
In my view, there is MFN treatment. As I told you.
It's welcome. Thank you.
Thank you very much, Honourable Chairman, ladies and gentlemen. I represent the Swiss National Centre of Competence Trade Regulation, as well as the World Trade Institute, and at the Swiss National Centre of Competence Trade Regulation, we do substantially work on trade and energy, and as well as climate change. So, in this presentation, I'm going specifically to address the European Union's and the Russian energy dialogue, and more specifically, I'm going to speak about the challenges in the electricity sector. So why did I choose this topic? For one simple reason. Because currently, Lithuania, Latvia, and Estonia are disconnecting from the former Soviet Union electricity system, meaning that if Kaliningrad won't follow Lithuania, Latvia, and Estonia, it might become in a situation that Kaliningrad will have an isolated electricity system. So therefore, disconnection from the former Soviet Union electricity system and connection to the European system might affect trading possibilities in electricity between Kaliningrad on one hand, Lithuania, Latvia, Estonia, Belarus, and Russia on the other hand, especially provided that there is no transmission link between Kaliningrad and Russia. So the structure of my presentation. First of all, I'm going to explain to you how did the wide area electricity transmission grids have evolved. I'm going to briefly introduce you with the historical reasoning. Secondly, I'm going to speak about the legal basis on the cooperation between Russia and the European Union. And I'm going to address partly the PCA that was addressed by the previous speaker. Now, thirdly, I'm going to focus on the regional cooperation between Kaliningrad on one hand and Baltic states on the other. And fourthly, I'm going to address some of the legal challenges that I think are of great relevance to this region. My approach is going to be based on the European Union framework, and I'm going to criticize and tell what is, in my opinion, wrong with the European Union's framework, specifically in the energy sector. And lastly, I'm going to give you some conclusive remarks. So, marked in brown, it's the EPS-UPS electricity system. It is a synchronous zone which connects the electricity systems from the Baltic states to Siberia. Marked in green, it's the European electricity system, which goes from Poland to Portugal. Now, integrated power system, unified power system, covers 15 countries, and all of them are the former Soviet Union countries. Basically, the system has expanded within the change of borders of the Soviet Union, and therefore, at some point, even the eastern part of Germany was part of the electricity system of the EPS-UPS. However, once the Soviet Union has fallen down, collapsed, the Germans, Polish, Czech Republic have disconnected from the former Soviet Union system and they connected to the European system. So this is why we have a situation, let's say, that Latvia, Lithuania, Estonia, which didn't follow the Polish, didn't follow the Eastern Germans, are part now of the former Soviet Union system. Now, the synchronous grid of continental Europe dates back to 1929. It was the idea to build back when an electricity system which would cover the territories of all the European states. Before merging into the European network of transmission system operators in electricity, the continental European grid capacity was 631 gigawatts, and it represented 34 transmission system operators in 21 countries. Now, the thing is that Lithuania, Latvia, and Estonia are disconnecting from the former Soviet Union electricity system, and they are connecting to the European electricity system. So therefore, the European electricity system will expand its geographical scope. Now, coming to the legal basis, what's the legal basis for the cooperation between Russia and the European Union? As discussed by the previous speaker, the legal basis is mainly the Partnership and Cooperation Agreement, which also partly regulates issues governing energy trade and also inter alia electricity trade. So, in the year 2000, European Union and Russia have decided to establish the energy dialogue because they identified a number of issues that need, or in other words, require sectorial approach. And these issues also govern the infrastructural issues. The European Union and Russia have both agreed that in order to expand the trading possibility between Russia and the European Union, we need to put a mutual effort in planning the grid. So for a number of years, please. So for a number of years, the European Union and Russia have been planning the grid expansion. They have been having certain dialogues at a very high political level, as well as dialogues between experts. Now, another legal basis. In 2009, Russia, as was discussed by the previous speaker, has rejected the application of the Energy Charter Treaty, and in 2012, Russia has joined the World Trade Organization. Therefore, the principles and rules governing the World Trade Organization are applicable between both Russia and the European Union. So, in a nutshell, WTO and Partnership and Cooperation Agreement are the two main legal frameworks that govern the relations between Russia and the European Union, and this is also true in respect of energy trade. Next one. Now, speaking specifically now, moving towards very interesting things. Now, regional cooperation. Transmission lines connect Lithuania, Russia, Belarus, and Latvia. Kaliningrad, as I mentioned, has no direct electricity transmission links with Russia. Lithuania, Latvia, and Estonia are disconnecting the system from the Russian system and connecting to the continental European system. And the main question is, of course, can the Kaliningrad electricity system function in isolation? Now, this question has posed a number of times by a number of politicians. What will happen once Lithuania disconnects from the Russian system, and what will happen whether Kaliningrad will be able to generate enough electricity to supply to people or to businesses, etc. And to my understanding, this is a very wrong question to ask, because from the trade law perspective, the goal is to facilitate trade between countries. The question shouldn't be like if Kaliningrad is able to supply enough electricity. The question should be what measures should be taken in order to facilitate trade. Now, what's the reason why Lithuania, Latvia, and Estonia are disconnected from the Russian system? They say that, well, we are highly dependent on Russia. Moscow might want at some point tell us that, well, we need to reduce electricity generation or whatever, and that affects our security. Now, if you would speak at expert level, you would find out that synchronization is purely a political concept. Nowadays, there are technologies like high voltage direct current technology, which allows to connect and trade in electricity between unsynchronized electricity systems. So the map that I showed you, the green color and the blue, doesn't mean that trade in electricity is not possible between green and brown. It simply means that technical measures have to be taken. For instance, construction of high voltage direct current line between these two different regions in order to create the trading capacity. And Russia apparently follows the argument of the European Union, and they say, like, fine, if you disconnect from the EPS, UPS system and continental Europe system, that's your right. However, in this respect, there are no discussions within the framework of the WTO, and I think this is quite bad. Next. Now, briefly, currently, Lithuania as well as Estonia are implementing several high voltage direct current projects. Like, these projects will basically enable electricity trade or will expand the possibilities to trade in electricity between these countries. Russia has proposed also several projects. A power link between Russian and Polish, a power link between Russia and Germany, and a power link which would increase the transmission capacity between Russia and Lithuania. However, these projects are still pending because there is a huge conflict over Ukraine between the European Union on one hand and Russia on the other. So it's very unlikely that the dialogue in the electricity sector will further continue towards implementation of these projects, which would open trade possibilities between the jurisdictions that I have just mentioned. Now, like briefly, also I have to mention that in 2002, the Electric Power Council of the Commonwealth of Independent States have initiated a dialogue suggesting that European and Russian electricity systems should be interconnected and synchronized in order to achieve the goals of free trade of electricity in the long run. So both the European Union and Russia have agreed to this political objective, and in light of that, a number of feasibility studies have been carried. Feasibility study, the first one was prepared in 2003, and the last one was in 2009, and all of these studies basically confirm that there are technical possibilities to synchronize the electricity networks of the European Union and electricity networks of Russia. Next. Here are the main advantages, and I'm going to address. Next. So, okay, given the framework that I have just discussed, I'm going to briefly outline some of the legal problems that are, I believe, of importance to government review. So first of all, implementation of the third energy package. As discussed by the senior colleague, currently there is a dispute at the WTO on the implementation of the energy package. The question is, does the European Union has the right to unbundle or not? I'm not going to give my opinion on that, but I think that's a very important question that is going to be addressed by the World Trade Organization, which will tell how far the European Union can go. Second, justification of the renewable energy support schemes. Just recently, the Court of Justice of the European Union has issued few decisions, Allens and Essen. In these rulings, the Court of Justice of the European Union has told that a member state of the European Union has a right to limit access to subsidy schemes for renewable energy for its undertakings. What does it mean? For instance, if a Kaliningrad company which produces electricity and wants to participate in Lithuania's market goes to Lithuania and asks for the same conditions, it won't get that because Lithuania may say, sorry, this is a national support scheme, and this national support scheme is only accessible to our local companies. And why is that a problem? Because electricity systems are interconnected. Because electricity, and once electricity gets into the electricity grid, you cannot distinguish whose electricity is that. So the question is, who is going to fill that transmission capacity? So therefore, in that sense, Kaliningrad companies are in competition with Lithuanian companies. However, Lithuania may undertake measures which would limit access to subsidy schemes to Kaliningrad companies. And the Court of Justice says that's fine with such schemes because environment is very important, because we want to combat climate change. And I think that if you would challenge the European Court of Justice ruling like this, you might have the potential to win at the WTO. I'm not going to give a conclusive opinion, I think that's an issue. Now, the third point. The European Union Renewable Energy Directive, Article 60, it gives a legal basis to provide priority access and dispatch of electricity on the grid generated from renewable energy sources. In very simple terms, you have an electricity grid and you have a limited capacity to trade in electricity because you cannot transport more electricity than transmission lines allow you technically to do so. So what do the European rules say? That if you have generated electricity from, let's say, nuclear power, on one hand, and renewable, like wind or solar on the other hand, you have to give a priority for the wind or solar electricity. So therefore, let's say the companies which produce conventional electricity won't be able to sell their electricity provided that there is enough electricity generation from the renewable energy sources. And that's a huge problem because this is how the conventional electricity generators are pushed from the market. Now, what's the question from the WTO perspective? The question is if conventional electricity and renewable electricity can be treated as like or not. And that's in fact a very difficult question. And whether it's like or not, I'm not able to say, but this is going to be, I believe, discussed in the future by panel or even appellate body, and as well as academics. Now the fourth thing, regulation number 2009/740. It facilitates cooperation based on regional pledges and organization principles that exclude the member states, non-European Union member states. Now, why is that a problem? Briefly, 2 points. First of all, Lithuania, Latvia, Estonia are, as discussed, interconnected with Kaliningrad and Belarus. So the region, speaking in technical terms, is defined not on technical basis and abilities to trade electricity, but on jurisdictional terms. And that's bad because if the European legislation provides a legal ground to, for instance, to impose special measures like, for instance, right now the Baltic states transmission system operators have agreed to purchase, first of all, the domestic electricity, and only what's left in only the remaining capacity can be subject to participation by, let's say, Belarusian companies. And that's bad because this is how you limit trading possibilities. And this also ignores, I believe, some of the rules of the World Trade Organization. I'm not going to discuss. So, final note, conclusion. There is a political tension, true, between the European Union and Russia, and that affects the cooperation in the energy sector. However, in the end of the day, we need cheap electricity. And in order to achieve this political objective and economical objective, cooperation is needed. It's important to produce electricity where, let's say, renewable electricity, where the sun shines and where the wind blows. It's important to use the competitive advantage of each and every state. However, these possibilities are a bit limited under the ambition of the European Union to create an internal energy market. And these policies do, to some certain extent, affect Kaliningrad. And I think that should be changed in the long run. Thank you very much.
В связи с политическими проблемами и напряженностями остается сложным вопрос о перетоке электроэнергии из Калининградской области в страны Евросоюза. Вступление в ВТО, России в ВТО, в частности, предполагало, что всякие ограничения по передаче на хороших основаниях электроэнергии из Калининградской области будет обеспечено. А с учетом строительства атомной электростанции возникают проблемы. Насколько будет востребовано в случае завершения строительства станции этой электроэнергии в странах Евросоюза. И в этой связи вопрос. После урегулирования каких-либо отношений между Россией и ЕС, как вы оцениваете перспективы передачи излишней электроэнергии от энергетических мощностей, которые имеются в Калининграде, в Польшу, ну и, соответственно, другие страны, в частности, используют там, допустим, подводный кабель или другие способы передачи. Спасибо.
In fact, the questions are very relevant given where Kaliningrad is based. Now, first question. At some point, not only Kaliningrad and Russia had the ambition to build a nuclear power plant, but as well as Belarus, as well as Lithuania. Lithuania has failed. We won't build a nuclear power plant because there are many political discussions on that, and it's a very expensive project, and public opinion, I believe, is more against nuclear power. I know also that Belarus hasn't progressed a lot in implementing the nuclear power project, but I don't know what's the situation in Kaliningrad. However, what I can say is that if Kaliningrad would manage to construct the nuclear power, it would need to find markets where Kaliningrad could sell this electricity. Because if Lithuania, let's say, Latvia, Estonia, Poland, the markets which are close to Kaliningrad won't give access to the electricity networks, Kaliningrad won't have any possibilities to sell electricity. So therefore, electricity generation from the nuclear power plant would be too excessive. And therefore, as a consequence, the Kaliningrad's power system won't be able to integrate such a large quantity of electricity, and therefore, such project wouldn't be feasible. However, if Kaliningrad would be able to build the transmission links to other markets, like German markets, Polish markets, the Swedish markets, or Norwegian markets, the nuclear power, the electricity generated from a nuclear power plant might compete in different markets, and therefore, as a consequence, this project might have an economic sense. Now, the second question was...
Ответили на вопрос?
Да. Thank you very much.
Okay.
Okay, yes.